Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Welcome to the 14th Court of Appeals, coming to you by Zoom session. I'm Chief Justice Kim Frost. With me on this Zoom session is Justice Charles Spain and Justice Margaret Poissant. Together we are here to hear the appeal in case number 141900751-CV Sinha versus Niebuhr. Each side will have 15 minutes to present argument. If the appellant wishes to reserve time for rebuttal, let us know and we will set the clock accordingly. We might have more pauses than is typical if we were in our courtroom together, so that we'll have time to switch the microphones and so forth. So I'll just warn you in advance that we'll be doing that. So we will begin with the appellant. We're ready to hear your arguments.
Thank you, Your Honor. This is Tom Nye. I would like to reserve 5 minutes for rebuttal, please. May it please the court. My name is Tom Nye and I represent the appellant, Dr. Sinha. This is the second appeal of a section 74.351 expert report case. In the first appeal, Chief Justice Frost, writing for this honorable court, held that plaintiff's expert, quote, provided no explanation why the laparoscopic surgery performed 8 days after the appendectomy, if performed earlier, would have yielded clear results in identifying the source of the leak and addressing the problems. Chief Justice Frost concluded, accordingly, the report fails to offer a reason free from inconsistency that but for Dr. Sinha's failure to perform the exploratory surgery, the outcome would have been any different. Plaintiff did not appeal this court's holding, and on remand, this defect was not corrected. I'd like to address the deficiencies in the expert report in 2 respects. Number 1, the inconsistency with known facts remain in the report. And number 2, the how and why requirement for causation as mandated by the Texas Supreme Court is missing. With respect to the first issue, plaintiff's expert report is not free from inconsistencies, and this is fatal to a proper report. And I'd like to examine this in 3 respects. Number 1, the first objective evidence of an intestinal perforation occurred on July 24th when Herman Hospital performed the exploratory laparoscopic surgery. Number 2, despite irrigating and cleaning the area, no perforation was found. And third, even though Dr. Sinha could have completely complied with the standard of care outlined in the expert report, it would not have prevented plaintiff's injuries. Let me examine these 3 inconsistencies in a little more detail. First, with respect to the finding of vegetable matter on July 24th. The known fact is that the first objective evidence of any perforation was on July 24th. This is inconsistent with plaintiff's expert report that said the intestinal perforation started after the appendectomy. And therefore, we have an inconsistency with when the internal perforation started. The specific known facts are the vegetable matter found by the surgeons at Herman Hospital on the 24th. In addition, there's other objective evidence that's inconsistent with plaintiff's expert report. There are 3 prior CAT scans, one performed the day after the appendectomy on the 17th, one performed on the 18th, and one on the 23rd, just prior to the plaintiff's transfer to Herman Hospital. There is no finding in any of those 3 CAT scans of any intestinal contrast material. Compare that with the finding of vegetable matter by Herman Hospital on the 24th, and also the CT scan performed the next day at Herman Hospital on the 25th, where the CT report found, quote, large amounts of enteric contrast material. That's intestinal material was found. So we have an inconsistency in the objective findings of the CT scans prior to and after the arrival on the 21st at Herman Hospital.
Counsel, is the argument in your brief in regard to the 3 CT scans?
There is a discussion about the inconsistencies, but that particular one is not discussed directly, but is an extension of the inconsistencies that we discuss in our brief. There's a second inconsistency, and that is despite irrigating and cleaning the area, there was no perforation found by the doctors at Herman Hospital. The known fact is that the standard of care required that Herman Hospital or any doctor perform an exploratory laparoscopic surgery, and had one been done, they would have been able to discover the intestinal perforation. But we know that Herman Hospital performed the exact procedure required in the expert report, the exploratory laparoscopic surgery. Nonetheless, even though they cleaned it and even though they irrigated it, no intestinal perforation was found.
And counsel, I have a question about that as well, if you don't. In regard to that laparoscopic exploratory surgery, that surgery you were just discussing, it was to clean and irrigate the wound, or was it to investigate as to the cause of the infection or problem that this particular person had?
It's not clear from the expert report and the exact precise purpose of it. There is the CT scan that's discussed on that was taken on the 23rd, talked about pelvic fluid collection. Again, there's no reference to any intestinal material, and so whatever area they were looking at, clearly there was a reference to the earlier appendectomy. And so they cleaned the area and they irrigated it, they perforated it, they aspirated it, and they still could not find any perforation.
Okay, so it's your contention that they were conducting that laparoscopic surgery in order to make a determination about what might be wrong or what might be causing problems or infections for this patient? Or was it merely a laparoscopic surgery to clean and irrigate the wound?
Well, I think regardless of the purpose, well, first of all, the purpose of the exploratory laparoscopic surgery is not set forth in the expert report, so that's unclear. But regardless, they say that they cleaned the area and they aspirated the area and they also irrigated. They could not find any intestinal perforation. So even though Herman Hospital performed the exact same procedure required in plaintiff's expert report, they could not find any intestinal perforation. The expert report stated that Dr. Sinha was required to perform the exploratory laparoscopic surgery. And had he done that, he would have been able to identify the intestinal perforation. So the same standard was complied with by Herman Hospital, but they could not find it. And it would be improper to hold Dr. Sinha to a higher standard to have said that he would have somehow found it.
Did the amended report address that, and why didn't the amended report suffice to cure it?
Well, the amended report did not cure it because there's a problem, like I said, because with, for example, I will start with the necrosis. One of the things that Your Honor outlined in your opinion previously was that the amended report needed to address the necrosis. In the amended report, they say that the necrosis would have started approximately 3 to 4 days after the completion of the appendectomy. But even though they included that in their amended report, the time period that they required Dr. Sinha to have performed the surgery overlapped with the onset of necrosis. So there's a window of time of about 1.5 to 2 days where he could have completely complied with the standard of care, but the harm would have already occurred. He could not have prevented the plaintiff's injuries. And so that attempted correction in the amended report did not solve the problem.
But how do you respond to the expert's statement that if the surgeon had gone in and performed this laparoscopic exploratory surgery and found bleeding, and I guess there were vascular clips that were applied to an artery nick, that he would have discovered the bleeding and stopped it, which would have prevented the necrosis and the subsequent need for surgeries to repair the issue?
That's deficient because it only addresses the intestinal, it only addresses the bleeding from the appendectomy site. It does not address the alleged perforation of the cecum, which was leaking matter into the abdominal cavity.
And when you say alleged, if you do a laparoscopic procedure or you open someone up and you find that there is food particles and other things like that, is there really a question whether something is, leaking somewhere and it's just a matter of finding where, or does food just show up in people's abdomen?
No, I agree with you, Justice Spain, that no, that's an indication for the first time that there is a perforation on the 24th. It could have occurred during that time period because the CT scans established proof positive that there was no prior leakage of the intestine because it's devoid of any finding of intestinal material.
But it wouldn't have been the standard of care, would it, that if the doctor couldn't find the perforation, that you just said that the doctor would go, well, everything's fine, even though I'm finding, ingested food in the abdomen?
Well, I think that there's certainly, if you find that there is intestinal matter in the abdominal cavity, yes, that there's an obligation to go forward. They waited 4 days before they did the second surgery. But the problem here, there's a disconnect as to whether or not there was a leakage in the cecum prior to the 24th.
How exactly, how does the unknown factor of exactly when the necrosis began impact the legal analysis here?
It's because that, as per the plaintiff's expert report, they say the necrosis began 3 to 4 days after the appendectomy. If you take that window of time and then you overlap the dates by which the plaintiff expert says that the exploratory surgery should have been done, there's a 1.5 to 2 day window by which he could have complied with the standard of care and performed the surgery timely, but the necrosis had already set in. And that's the type of inconsistency that has to be reconciled, and the how and why is not stated in the expert report. I see that I'm out of time, so I'd like to reserve the remainder of my time for rebuttal.
Right. Thank you. We'll have a slight pause. Thank you.
Mm-hmm.
Now we'll hear from the appellee.
May it please the court. My name is Lynn Clement, and I have the pleasure of representing Roger Niebuhr, the plaintiff in this case, who went through this unfortunate experience. The purpose of the expert report is to inform the doctor of specific conduct that the plaintiff alleges he did wrong, and to provide a basis for the trial court to find that the claim has merit. Judge Holder found that Dr. Chestovich's report met those standards. And to overrule Judge Holder, this Court of Appeals must find that she acted arbitrarily, capriciously, and without reference to legal standards. That's a high burden to meet, and I don't believe the appellants met it. What are those standards? We look to the Supreme Court. They've laid them out in 5 cases that I think are the critical ones for this type of a case. Certified EMS versus Potts, Van Ness versus East TMC, Miller versus JSC, and Absher versus Christus Health. In certified EMS versus Potts, we hear the first time the court really saying that the purpose of these reports is not, in the review of them, is to deter baseless claims that will have no merit, not to impact on or block earnest claims. So there are 3 steps to inform the doctor of the conduct and to meet the adequacy of the report. You got to address what the standard of care is. You got to show how the standard of care was breached, and then you got to establish some causal relationship between the breach and the injury. And this appeal is only about number 3. The other 2 have already been met. So, Justice, excuse me, Justice Frost, I believe you wrote the original opinion in this case, and you found 3 mistakes or 3 errors without adequate information. Location of the intestinal leak. That's clearly been addressed in the amended report. How and why necrosis developed. That is explained in detail in the amended report. And the 3rd one is how the earlier surgery would have likely found the problem when the 724 surgery, laparoscopic surgery, did not find the problem. With regard to how and why the necrosis developed, I want to clear up something because it's been totally misinterpreted by appellant in this case. What Dr. Chestovich says in his report is that there was no necrotic tissue that developed within the first 3 to 4 days. So what he's saying is, as of July the 20th, when Niebuhr went to Houston, there was no necrotic tissue. So that whole argument that he just went through in detail is a red herring. That's on page 4 of Dr. Niebuhr's report, and it clearly says no necrotic tissue had developed within 3 to 4 days after the appendectomy surgery. I don't think how you can interpret that any other way. Regardless, what the standard of care was called for in the report by Dr. Chestovich was for Dr. Sinha to realize that something had gone amiss when this guy had blood and he had an infection. He had elevated white blood cell, and it called for him to do an exploratory laparoscopic surgery on 7/17. Even if the necrosis had already set in by, say, September the 19th or 20th, it's immaterial. He's had the opportunity to prevent that from happening. So it's a red herring in 2 ways, all right, when we look at the report in its detail. So the issue is, in the essence of this appeal, is that Dr. Chestovich basically says that the necrosis developed sometime between 7/20 after he left Brazosport and the 23rd, or the 24th, when they did the exploratory surgery. So about a 4-day period in there. And he says, without deviation and without controversion, that if Sinha had met the standard of care and performed exploratory laparoscopic surgery on July 17th timeframe, the bleeding and leakage would have been identified and Niebuhr would not have developed necrosis. Dr. Sinha may disagree. Members of this court might disagree, but that is not the issue at this stage. So let's address why a 7/17 lap surgery would have found the leakage and the bleeding. First of all, I think it's clear from the report that the 7/24 laparoscopic surgery at Memorial had nothing to do with trying to find a leak or anything else. It was just to reopen, see what was going on. They found all of this infectious material, the vegetative material, the blood. They tried to clean the wound and hope that that would help improve things. There is no indication in the report, because there was no indication in the surgical report, that they were looking for and trying to fix or repair any of the problems. Dr. Chestovich is clear that had Sinha done his surgery, a physician, more likely than not, is what he says, would find and repair the damage, whatever it was, on July the 17th. For Dr. Sinha to argue that he could not have, because they couldn't do it on the 24th, when there's no indication that they were looking for it, he could not have done it, is essentially for him to argue that he's not a competent surgeon. Because the report says, in reasonable medical probability, that means that assuming a competent surgeon carried out a laparoscopic surgery in the July 17th timeframe, more likely than not, he would have found the problem and a competent surgeon would have fixed it. That's the standard of care. That is the breach. And that is how that caused the problems down the road, because it's unequivocal in the report that the continued leakage, continued bleeding that was going on after 7/17, when the exploratory lap should have been done, that's what caused necrosis to develop. As you said, as counsel said, and as the cases say, you got to establish a timeline from the breach through the injury. And Dr. Chestovich has done that. This timeline is: the failure to repair is the breach of the standard of care. Continued leakage and bleeding for days afterwards because of the failure to repair results in a development of necrosis, which results in the need to remove the right colon and perform an ileostomy that Mr. Niebuhr has to live with. If we turn to the Texas Supreme Court for some guidance, for example, in Absher and Miller, they call out the fact that the appellant or the doctor may disagree with the timeline as presented by the expert. They may disagree with the analysis or the conclusions, but that is not what we're to do at the expert report stage. You may disagree, but that is for some time later in the process, when the actual opinions can be delved into and see whether they're medically probable. And as the court says, the Supreme Court, disagreement with the opinion in the expert report does not render the report conclusory or show analytical gaps in the report. So a couple of the cases I want to bring out that are Supreme Court cases that are very important in this: Van Ness versus East Texas Medical Clinic. This was a child who died of whooping cough. He saw his doctor 3 times, on December 11th, 15th, and wasn't evaluated or treated. No x-rays were done. He was finally treated on December the 20th, and they identified the whooping cough, pertussis, as it is. In that report, the doctor actually contradicts himself. He says antibiotics have little chance of changing the outcome in an infant that's not been vaccinated. Then later in the report, he says that had antibiotics would have been given to the child at one of those first 2 visits on the 11th or the 15th, there was a 51% chance of survival. He directly contradicts himself in the report, and yet the Supreme Court overturned under lower court findings of inadequacies in the report and basically said that he has one place in there where he says the failure to treat on those 2 days resulted in the deprival of this child's possibility of survival. That's similar to what's going on here with Sinha and his attempt to get hyper-technical about the timeline, implying that because Dr. Chestovich used 3 to 4 days, that maybe necrosis had already started on July the 19th or 20th. So what? The standard of care said you should have done the surgery on 7/17. And ultimately, Sinha was the only doctor, the only person in the treatment of Mr. Niebuhr who had the ability to prevent the necrosis and the colon removal and the ileostomy. Miller versus JSC has some inconsistencies in it too, in that the report says the dental bridge that got lodged in the woman's throat could have caused aspiration and death. Didn't say it did, kind of questionable about its causation nature. But the Supreme Court went on and said, overturning the Court of Appeals, that that was adequate because, in fact, it did cause aspiration and death. So the failure to explore laparoscopically did cause the necrosis to develop in this particular case. And it said the trial court in particular, could have reasonably determined that the report represented a good faith effort to establish the causal relationship. That was the burden that Judge Terry Holder had in this case. And she could have reasonably determined that the report of Dr. Chestovich actually provided the necessary information about standard of care, breach, and causation. The Beatty versus Futrell case, both the trial court and the Court of Appeals found the report to not be adequate. And yet this was the one that's a very cursory report about don't stick the optic nerve with the needle, stuck the optic nerve with the needle, that caused the damage. That's essentially all that's in the report. And Supreme Court found that both of those courts had abused their discretion in finding that report not to be adequate. They cited with approval a case, Garza versus De Leon, that involved injury to a child during a circumcision. They approved this hearing, this finding of lower court. The expert in that case only offered 3 different things that might have happened to cause the problems with the little boy's penis. You know, might have been pressed too hard with a clamp. He might have cut too deep, might have burned too deep. Don't know which. But in fact, the Supreme Court, overruling the lower courts, said that was enough of a report to be adequate to put the doctor on notice of what he did wrong and to find that the case had merit. And then Absher versus Christus Health. This is the brittle bone disease, and it talks about the nurses failing to adequately chart the case. The Court of Appeals had overturned or found the report inadequate. It uses the term, there's an analytic gap. And the Supreme Court goes out of its way in a footnote to say that it has never used that term, analytic gap. Doesn't really know for sure what it means. But it's basically interpretation of the way this Court of Appeals went in that is that they didn't agree with the experts' causation, conclusions and causation, on causation. But that's not this court's job. Disagreement with the report does not render it conclusively. This court's job has the expert explained how the conduct caused the injury. Failure to do a laparoscopic exploration on July the 17th or even for days thereafter, when the standard of care called for it, results in a failure to diagnose the bleeding and leakage if there is one. As a result, the leakage and the bleeding continue, necrosis develop, injury, right colon removal, and ileostomy. The last thing I wanted to bring up with the court just briefly was the Karkutli case that this court cited in its first opinion. The problem with Karkutli was not that the doctor said the earlier surgery would have alleviated the problem. The problem with Karkutli is that the doctors in his report never provided any information about the subsequent surgery and what it found or whether it found any problems or whether the sepsis was there or anything else like that. The expert in that particular report said that what never tells you what was found 10 days later to show why earlier surgery might have been different. Here, Dr. Chestovich gives specifics. The surgery found necrosis. He tells you that necrosis wouldn't have been there earlier on. So we have a completely different situation than we had in the Karkutli case. Although you're still, both cases are dealing with this question of why an earlier treatment would have prevented the adverse outcome. In this case, we have a clear explanation of why earlier surgery would have prevented necrosis, because necrosis takes days to develop. With that, Judge, Your Honor, that's basically my argument. And I appreciate your attention. Thank you. If you have any questions, I'll be happy to answer them.
Your panel members have any questions?
I do have one question. You know, your opposing counsel brought up the 3 CT scans. Do you have a response to that argument that he made regarding CT scan results?
Yes. Counsel is arguing the medicine of this case. He's not talking about the adequacy of the expert report. There is no evidence. There's no statement by anybody. There's nothing in the reports about whether or not a CAT scan would pick up vegetative matter, or whether it's just going to indicate that there's things in there that shouldn't be in there. Even the post 24 CT scan does not refer and say to vegetative matter. It says that there's contrast media in there. Mm-hmm. So there's nothing in the record anywhere that would say that a CT scan on back on the 17th, when the surgery should have been done, would have shown that there was vegetative matter in the peritoneal cavity. We don't, I mean, that's arguing medicine and has nothing to do with merits and the adequacy of the report.
Thank you, Mr. Clement.
Thank you.
We'll pause for Mr. Nye to come back for rebuttal.
May it please the court. The CAT scan performed on the day after, on the 25th, the day after Herman Hospital performed their exploratory laparoscopic surgery, did make a specific finding regarding enteric material, which is intestinal material. That is a direct contradiction to the absence of such a finding in the prior CT scans. Let me next address the issue regarding Absher and Miller. The Absher and Miller cases discussed by opposing counsel did not involve any inconsistencies. So you have inconsistencies in this case that are not explained, but you did not have it in those two cases. There was an inconsistency in Beatty, and I would refer this court to the Texas Supreme Court opinion at page 698. The Supreme Court said, the plaintiff's expert also notes other postulated causes of Beatty's vision loss were ruled out by subsequent examination or ancillary studies, and that Beatty had previously undergone successful cataract surgery on her right eye. And that's the key distinction here. You have the expert in Beatty explaining away the inconsistency. Well, it could have been this that caused the vision loss, or it could have been that. Well, we don't have to agree or disagree with the reasoning, but it was explained away. And what the problem with this expert report, it only has a conclusion. If you perform the exploratory laparoscopic surgery, somehow, some way, you would be able to identify the intestinal perforation. There is no how, there's no why that would have happened. And that is what makes that expert report deficient. And the Beatty case is on point that you do have to explain the inconsistencies. And if you do not, you have a defective expert report.
Does inconsistency matter?
I'm sorry, Your Honor?
Does every inconsistency render a report insufficient? How is the inconsistency material here?
It has to be material to causation. And I would cite this court to another Texas Supreme Court case, and that is in the Texas Supreme Court in Jelinek kind of addressed this exact issue at page 536 about these inconsistencies. And it says, the expert must explain why the inference drawn is medically preferable to competing inferences that are equally consistent with the known facts. So if it's relevant, like in this case, to causation, and there's a conflict with known facts, those have to be reconciled, just like it was in Beatty, where they said, no, there's a reason why there was an explanation why there was a vision loss or no vision loss. And is
there a distinction here, though, in some of the factual statements on which the expert are based, like between the leakage and the bleeding?
I think that there is a distinction here because they say that there were two different opportunities to identify the intestinal perforation, and that if on the 17th, if they had gone in to resolve the bleeding issue, that somehow, some way, they would have been able to discover the intestinal perforation. But again, the how and the why is missing from the expert report. There's no link there.
So the fact that there is food material in the abdomen, which I assume nobody's arguing based on the expert reports that's what was found at Memorial Hermann. Is it the fact that the perforation wasn't found? It's and there wasn't an explanation for that in the expert report. Is that the issue, that the doctor didn't give in his expert testimony, that food doesn't show up, in the wrong place in the abdomen unless there's a perforation? Is that the problem?
I think the problem is the failure to explain why there was no evidence of a perforation prior to the 24th by way of
the food itself is no evidence.
No, I think the food is evidence of that there's an intestinal leak. We know for a fact there was an intestinal leak on the 24th. That's okay. The very first time.
And it could have existed earlier, but we know it on the 24th.
It could have existed, but it may not have existed. That's the inconsistency that's not explained. And it's up to the plaintiff's expert to explain that and absence of explanation is an improper expert report.
Is it then your opinion that the expert should have made some kind of differential diagnosis and ruled out other causes in this case?
I do think they have to rule out other possible causes, for sure. That's done in the Beatty cases, and that's done in other cases where you have known facts that make it inconsistent with the conclusions reached. And there's no explanation, for example, about the onset of necrosis. They clearly set forth a standard of care that the surgery should have been performed between the 18th and the 20th, but 3 days after the appendectomy is the 9:20 a.m. on July 19th. And he certainly could have complied with the standard of care, performed the surgery on the 19th or the 20th, but there could have been the onset of necrosis.
Well, was there any evidence of some intervening cause or something else that you contend would have been the cause for the perforation?
We just don't know. It could have been a fall. You had the examination on the 24th said there was multiple abdominal hematomas. Something caused the spike in the white blood cell count, but those things aren't explained away. It could have been that the perforation was so small that Herman Hospital couldn't find it. Neither could Dr. Sinha have.
Well, is any of the, I was looking through the briefs and I didn't see any of that argument in the briefs regarding differential diagnosis or a possible intervening cause or any type of argument in that regard.
It relates to our argument about the how and the why. You have to explain how that would have happened, how they would have found the intestinal perforation, and why it would have happened. That argument is in our briefs, and we do cite to the other Supreme Court cases, especially the Beatty case, where the distinction is made there, but not made in this expert report.
So is it now your contention that the expert report, in order to not have a deficiency, should also have addressed differential diagnosis?
No, it's the inconsistencies. So if the inconsistencies involves another possible cause, then yes, you have to address that, okay? It's what the Chief Justice put in the original opinion. It's not free from inconsistencies. And those inconsistencies were not corrected in the amended report. And as such, they remain defective, and it's not a proper report. They hold Dr. Sinha to the standard of going in earlier to find the intestinal perforation, but Herman Hospital did the same standard of care procedure. They performed the exploratory laparoscopic surgery, but they could not find the intestinal perforation. It's that type of inconsistency that remains unresolved.
I guess the issue that I'm a little troubled by is this the lack of specific words in the report, or like it could have been something else, but there's no evidence of that. And it could have been the appendectomy, there was a perforation, and by the time we found the food, even though it was hard to find the perforation, we knew what the problem was. I mean, did the doctor have to exclude, there's no evidence that he got into a fight and was hit multiple times in the stomach by an assailant?
I think he has to exclude other reasonable causes. Well, I would go back to Jelinek, where if there's equally likely inferences, the burden is on the plaintiff to set forth a reason that's medically preferable to competing inferences and that are equally consistent with known facts.
But how is there a competing inference, counsel, when there's no evidence of any other causation?
What we have is inconsistencies with the known facts. The inconsistencies with the known facts is that Herman Hospital couldn't find the perforation, but they expect Dr. Sinha. That's an inconsistency that remains. Another one is the reference to the overlapping period of time in which there should have been, that according to the plaintiff's expert, the exploratory laparoscopic surgery, but the onset of necrosis, as per his own expert report, could have already been in existence. That is an inconsistency created by his own report that's not resolved. And it's that type of thing that makes it fatal to a proper report.
Anil, have any other questions?
I do not.
Justice Poisson?
No.
Right. Thank you for your argument. Thank you, counsel, to both of you for your briefing in this case and for your arguments here today. This case is submitted. You are excused and we are adjourned.
Thank you, Your Honor.
Thank you, Your Honor.